Courtroom buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast, witness takes stand, shadows cast, whispers loud like wildfire spread. In this game none's ahead. International eyes on the scene, lines of right blurred and lean. Arrested dreams, shattered glass, in this court who holds the past.
All right, welcome back, everyone, to part two of this wildness, craziness of a stream. Um, Okay, so like I said, I probably not gonna be on screen. I will come back when there is movement or anything, but I am gonna rest a little bit to carry on because by the time that they are done with this, it's gonna be close to 3 o'clock in the morning, and I will be up for the last almost 24 hours. So I just need to lay down a little bit, rest up, but I'll be in chat as always. And I guess I'll see you very soon. Oh, I will move to the parole hearings since there is still like it's a 4 hour one, so I will move to the parole hearing so at least we can listen to something while you guys do your stuff, and we wait. At least we are there's some background noise, but yeah, I'll leave that here.
Whenever he was incarcerated, they knocked on my door again. I had just got released. It was like 9:17. They knocked on my door hard and was saying they had another call for domestic again. They made a mistake again. I recorded it. I could email it to anyone, to his lawyer, to send to you. They made a mistake twice. I walked to them at the corner and I said, will this be a continuous problem? Because my kid's dad is sitting in jail right now for something they say we had domestic, just because we have a background. And he's saying I have aggravated assault. That all has been dismissed. Again, we're being stereotyped continuously. And it's crazy at this point because, of course, my children will be present.
Where I'm reading this from is the narrative in the police report. During the course of this investigation, it was learned that India is living at the address after receiving assistance from the Faith House. According to India, the Faith House helped her get the apartment after being involved in a domestic altercation with Domingo. However, Domingo now lives with India in the apartment. So that's from the police report. Anyway, so I just that's basically my concerns. The presence of the children during these domestic violence assaults. Okay, that's all I have to say.
Can I speak at this time?
Mr. Allen, I will allow you to speak, yes.
Thank you. Thank you. As a representative of Mr. Domingo, I'm hearing that you are basing and giving a lot of weight to a police narrative. Now, from an attorney standpoint, police narratives are hearsay, and they are reviewed by the district attorney's office. Those narratives that you are reading and giving great weight to have been reviewed prior to ever getting to this stage, and they were denied. And that means that they feel that they cannot reach the burden of proof, which is beyond a reasonable doubt. Right now, you're using those narratives and you're giving weight to them. From what I'm hearing, that this is leaning towards a revocation, whether that revocation came from the probation and parole at the hearing or whatever, because I didn't get those documents until this morning. 45 pages of documents I got this morning. However, I was there. Now, I do know that if this person was convicted, if Domingo was convicted and had his right to due process, then that would be a different finding. Because that at that point, the police would have been under question, witnesses would have been under questioning and everything. But here we have the actual victim here who is putting on statements and saying, hey, this stuff in this narrative is not true. So it's almost what I'm seeing here is that they could not convict him in a court of law under due process, which is why they did not bring it. But it seems to me right now, this is getting ready to be used against him as though those statements are accurate and true. And I just have a problem with that, because if that's the case, then we could have went to court, found him not guilty, And then hopefully it would have been a different outcome. But the district attorney themselves says, no sense in taking this to court because we can't reach the burden of proof of beyond a reasonable doubt. So none of those charges are being lodged against them, except for right now. It seems that you're going to use the narrative to bring those charges against him. And I think that that is legally and patently unfair to Domingo, because he was not given an opportunity for a due process hearing because they denied it. So that's my comment, purely from a lawyer's perspective. I think that I have a right to bring that forward to him. So that's all I did now. Thank you very much.
It is well within your right. At this time, Mr. Prater, do you have any questions?
No, ma'am, I don't have any questions, but I do want to make one thing clear because of the fact that there's so many people that listen to these and they don't always have the backstory. And the backstory is Mr. Domingo is not in jail, and we're not here because of a simple possession of marijuana charge. I just want to make sure that you understand he was convicted of possession with intent to distribute and given 10 years. And the only reason I mention that is because there's so many people that have the false narrative that our prisons are full of people that are charged with simple marijuana, and that is simply not the case. So it's nothing about Mr. Domingo. That case is in the past, and that's been dealt with. He's been sentenced, and he's gotten out on parole, and all is fine. And I don't want him. There's nothing against Mr. Domingo, but I just want to make sure that the persons listening to this understand the full charge that he was convicted of. And I don't have any questions about the case. Thank you.
It would be important to note, and Mr. Allen, you were within your right to bring that up. However, when someone is on supervision, they have a contract, and the standard of proof is not that of a court of law because they have violations, and we have preponderance of evidence that we use. So I just want to make sure that that you understand we have police reports which we use as evidence. Okay, in this police report, Miss India on the home invasion stated, now see, anybody can recant, and they do 90% of the time, but she stated to the police in the report that it was Mr. Domingo who became enraged and forced his way into the apartment, breaking the bottom frame of the front window. So we have her statement that this is what happened. Okay. At this point, is the panel prepared to vote?
Yes, I am.
So, Ms. Stapleton.
Okay, I'm going to revoke you based upon the domestic violence battery charge. And also, you do have a high tiger risk score, which is something that is considered.
Mr. Prater.
I'm going to concur because it doesn't make any difference because it has to be unanimous.
Oh, it does.
Oh, it does not have to be unanimous? Okay, I'm misunderstanding. I've got that confused with parole. I'm sorry. Well, that being the case, I think there's the high tiger score bothers me. Otherwise, I would say that I would vote not to revoke, but because of the tiger score and nothing else, and counting on somebody else's, besides anybody on this board or any testimony, somebody else's opinion of reoffending, I'm going to vote to revoke.
My vote is to not revoke, to mandate domestic abuse violence classes. However, today your parole has been revoked, and the location will be getting a notice. We are at the Lafayette Parish Corrections Center today at this hearing. Okay, that ends our business there, so it's 9:20, and we will adjourn.
Thank you.
Good morning. The Louisiana Committee on Parole is impaneled at headquarters in Baton Rouge. Today is January 7th, 2025, and the time is now 9:38, and we are in a hearing with Union Parish Detention Center. Would the offender please state their name and their DOC number?
My name is Stephen Medlin, and I do not know my DOC number. I haven't memorized it.
Okay, can you give me your date of birth? Yes, date of birth.
11/27/1990.
Okay, Mr. Medlin, your DOC number is 788-248. We're going to be dealing with some parole revocation issues. Let me introduce you to the panel. To my left is Ms. Stapleton. On remote is Mr. Prager. I'm Ms. Ledoux. We also do have your mother and your girlfriend. Mariah Reeves is your mother, Cheryl Morris' girlfriend. First of all, I'm going to ask you, do you have a piece of paper in front of you that shows your signature?
I have a piece of paper that I can sign, but I don't have one that I've signed already.
Okay, is it a parole revocation questionnaire? You see that now on our screen?
I do see that.
Okay, and that is your signature?
Yes, ma'am.
Okay, so Mr. Medlin, your answers to that indicates that you are not eligible for appointed counsel. Do you have a retained attorney?
I do.
And is he with us today?
He's not with me. I don't see him on the screen anywhere.
So he's not in attendance. We're going to continue unless you have an objection to that.
I do not.
Okay. So, sir, I'm going to be reading some information from your file and asking you to. You were charged with violating condition number 4 of your parole in that you were arrested on 9/24/2024 for second-degree battery and battery of a dating partner by the Union Parish Sheriff's Office. You can plead guilty, not guilty, or guilty with a statement.
Not guilty.
Okay. I will note that on 11/6/2024, the charges were declined by the district attorney's office. At this time, we'll allow your mother to make a statement before we start asking you questions.
Good morning. I'm Maura Reeves. I'm Stephen's mother. I'm all stuffed up this morning, so I'm gonna get through it. But I mean, I just wish y'all would consider. Stephen's got a daughter. He's got 3 nephews. We have a big family. We have a strong support system. When he gets out, if y'all let him out, you know, he does have his own house. He currently has a job in the oil field that keeps him stable and able to pay his own bills and pay his, monthly fines. He is remorseful. We have talked, we talk. He has some regret. You know, while he's been incarcerated, we have had some tough things, some death, and, you know, he's missed being able to say his goodbyes. And sorry. And you know, he is a member of our current church. We have a good pastor who's young, who's been to see him and is mentoring him. And, you know, I really wish you would consider letting him out. His daughter needs him. Our whole family needs him. And, you know, I just ask for you to consider that.
Thank you very much. We also have Ms. Morris, if you would like to make a statement at this time.
I would. And I believe, did you guys get, I had a notarized statement that was sent in for his pre-hearing.
Yes, we have that.
Okay. So, I mean, everything I said in that statement, hopefully you guys had a chance to review that, because I didn't want to go over it, but I did want to say a few things to maybe clarify and give some perspective as to why I acted out the way I did that night. So just a little back history. I'm a registered nurse. I'm working at a local hospital. I've been a nurse for 13 years. I graduated University of Maryland, Baltimore, with my bachelor's degree in nursing. I moved to Louisiana about 5 years ago, right before the COVID pandemic hit, as a travel nurse, when I was going through a separation and divorce from my husband of 20 years. That relation ultimately ended because of trust issues and infidelity. Looks like my power just went out. But there I found on my ex-husband's phone some things, and his social media apps, and unfortunately that has caused some lasting effects for me. Also, since that time, I've been diagnosed with borderline personality disorder, and one of the symptoms of that is emotional dysregulation. I have a very hard time regulating my emotions. I feel everything to the extreme. When I'm happy, but when I'm upset, it feels like my world is ending. I've been in therapy, and overall I've been doing really well, but sometimes I still have some borderline episodes if I'm triggered. And unfortunately, on the night of September 23rd, Stephen's phone was that trigger. I have a tendency to catastrophize, and when that notification went off on his phone and I saw a message from another female, I automatically jumped to the conclusion that he was cheating on me, and I reacted straight out of emotion and without thinking. I accused him of being a liar, and I hit him. And the fact that I had alcohol on board made it worse. I tend to get very emotional when I drink, and on top of it, I'm already a very emotional person. Because of this, I am a person who should not consume alcohol. It has caused some issues in my life. And I still have not had any alcohol since that night. I have made a firm goal not to pick up alcohol anymore. Stephen reacted in self-defense that night. He did not intend for me to get injured. And I believe he should not be punished for it. The court agreed with this and declined the charges before he could even be arraigned. As a side note, I would like to add that Stephen's grandfather passed away 2 days after he was incarcerated. He was unable to attend the funeral and be the pallbearer like was planned because of my actions that night. And now he's about to lose his uncle that he's very close with due to a recent and very unexpected diagnosis of stage 4 cancer. He was just put on hospice, and I'm begging you to allow him to come home and be able to say his final goodbyes. And that's all I have to say. Thank you.
Thank you very much. Mr. Prater, I'll turn this questioning over to you.
Yes, ma'am. Stephen, did you have 12 beers that night?
No, I didn't have 12, but I did have 6. That's all I bought that night. Me and that cop had got a little lippy with each other, and I just told him. He kept asking me questions, and I just said, "Look, man, I don't even know what's going on. If you want to write down that I had 12 beers, go ahead."
Okay. All right. Did you slam her head on the floor?
No, sir.
You just pushed her backwards and she fell and hit the cabinet.
Yes, sir. I was sitting in like a bar stool that kind of wraps around your hips. So when she attacked me, I had nowhere to go. I had to push her off of me, and then she fell and unfortunately hit her head on the handle of the cabinet.
Why didn't you leave?
Why didn't I leave?
Yeah,
It was my house. I went and got in bed.
I mean, why didn't you leave the house or something? If you knew she was irrational and drunk and gonna be a problem.
Well, when this first happened, we were outside and she hit me, and I went inside and I started fixing me a burger, and then she came inside. I was thinking I'm gonna separate from her, let her cool off, and then as soon as she come back in the house, she just come at me again. So I was just thinking if I walk inside, give her some time to cool off, she'd cool off, and that's not the case here. And everything kind of just happened real quick, all within. Everything was completely calm, and then with a matter of, I would say, 2 to 5 minutes, this event took place.
That's all I got.
Ms. Stapleton?
Well, when I read the police report, which involves Deputy Didier and a detective, they both say that they saw evidence of the crime as described by the victim. So the physical evidence was also they took pictures of it also. Did you strangle her? Did you put your hands around her neck and strangle her? That was in
No, ma'am.
No, you just pushed her and she fell? Because it said she had, there was blood on the floor from a bloody nose and all of that. I mean, it sounds like a pretty violent episode.
She didn't have any damage to her frontal face at all. There was 0 damage to her face. The only thing she
says that she was with an open palm, that she was hitting the nose and the upper lip.
No, that's where I was hit. That's
where you were at?
That's not the police report I read that says that anyway.
Okay. All right. Did you lost your temper and it got the best of you?
No, I just pushed her off of me to get some separation. She was hitting me. I just wanted to get some separation. I was kind of pinned in that chair.
Okay, that's all.
Mr. Madeline, you were on probation also at this time, or is just a probation as well?
I'm on probation and parole for the same charge.
Same charge.
Yeah, I took a split sentence.
Okay. I understand that you were asked to do a substance abuse evaluation. Did you ever complete that?
I did.
Okay. What were the findings of the evaluation?
They didn't recommend any treatment.
Okay. Were you employed at the time that this happened?
Yes, ma'am.
Where were you employed? It looks like you had benefits. Is that correct?
Yes, ma'am. I work for a company called Helmerich and Payne Drilling. They're based out of Tulsa, Oklahoma, and I was working in Midland, Texas. And I've been with that particular company, other than being incarcerated, since March of 2017.
Okay. So, I hate these cases where it's she said, he said, and all the recanting. And I mean, we have a police report and we have evidence of violence. Okay, that's what the evidence we have before us today. That's what we have to make our decision on, is the evidence that we have. Is the panel prepared to vote, Mr. Prater?
Ma'am.
Okay.
My vote is to revoke violation number 4. For one thing, being drunk. I mean, that's one thing, violation of your parole. And the other thing, I think something happened. It's just it was too logical of a story to come up with when you're drunk. If you're too drunk to know what's going on, you usually resort to the truth. And upon question, when the police get there, she went to the neighbors and she was too scared to ask you for the phone. All that doesn't make sense. My vote's to revoke violation of 4.
Stapleton.
I concur with Mr. Prater.
Mr. Medlin, my vote is also to revoke. And I do hope that you get some help with anger management and domestic abuse, violence issues, as well as substance abuse. So today, unanimous decision, your parole vote. The time is now 9:53, and that concludes our business.
Can you hear me?
Yes, we hear you. If you, so we can see. Okay, thank you. We are the Louisiana Committee on Parole, and we're impaneled in Baton Rouge at headquarters. Today on the panel, virtually is Mr. Prater. To my left is Ms. Stapleton. I'm Ms. Ledoux. Could the individuals there at St. Tammany identify yourself, please?
Yes, ma'am. My name is Deputy Mike Molinary.
Thank you.
Name is Roy Burton, ma'am.
And your DSC number?
453532.
Okay, Mr. Burton, you're before this panel today with allegations of violation of your parole. I'm going to read, well, first of all, do you have a piece of paper in front of you that indicates that you've signed a revocation questionnaire?
Yes, ma'am.
Okay. The answers to that indicate that you are not eligible for appointed counsel. Did you retain an attorney?
No, ma'am.
Okay. We'll go ahead and proceed. I'm going to read the allegations against you and ask you to enter a plea of guilty, not guilty, or guilty with a statement. Violation 4A says that you were engaged in criminal activity as evidenced by your arrest by the Louisiana State Police on 8/29/2024, where you were charged with DWI first. You had a blood alcohol content at the time of 0.203, and you were billed with misdemeanor DWI due to the fact that it had been 10 years since you had your last conviction. However, you're currently serving your sentence for DWI third, and at the time that you were arrested, you did plead guilty to DWI first. How do you plead now?
Well, ma'am, I do plead guilty to the DUI first. I talked to Mr. Tom over in Don over in time computations, because in 2017 I petitioned the St. Tammany courts to take that third offense DUI and run it concurrent with the 30 years I was doing for manslaughter. So that conviction should have been over. And when I talked to them, they said they took it out of Cajun. I talked to Jonathan Vining, and he said everything was taken care of.
That's immaterial in terms of, did you plead guilty to DWI first on 10/7/2024? Okay. The second part of that is you were issued a citation for hit and run.
Yes, ma'am.
Okay, and how did you plead to that?
Guilty, ma'am.
Okay. Number 10, you're currently $141 in arrears of supervision.
Yes, ma'am. And on the supervision, yes, I am behind. On the day that I was arrested, I'm on Social Security. On that day, I get my check, and that's when I pay my probation fees. When they first changed the way you pay, I pay online. And when they moved it to Texas, I couldn't get online for a month because the system was so, it wasn't properly set up and they were still working the bugs out. I'll pay that today.
That's not the biggest issue that's before us today. We have today with us Miss Ashley Williams,
Yes.
who is a probation and parole officer. I think that it would be an appropriate time for Ms. Williams to go ahead and address her concerns with the board.
Good morning. Thank you for allowing me to attend today. Yes, ma'am, I am seeking revocation for Mr. Roy. In addition to the hit and run and the DWI that we've already discussed, my concern primarily was the BAC. I have discussed it with our DA's office here, and they have verbally admitted to me that he should not have been eligible to even be billed as a DWI first, because that 10-year time period he was incarcerated, and LARS allows that they are not eligible for the DWI charges to restart if the reason they didn't incur a new charge during that time frame was due to incarceration. So that is obviously primarily my concern is public safety. I do feel like he did get a lucky draw with that. And I think he was aware of that, which is why he pled to it at the arraignment. However, I did not feel it appropriate in the idea of public safety to allow it to just be seen as a technical based on the fact that it was only a misdemeanor. I do want to bring to the board's attention as well. We did have a situation with Mr. Roy. He was erroneously released from St. Tammany Parish Jail at the beginning of December, back on December 5th. We were not made aware of it until January 3rd. So he was re-detained yesterday and placed back in jail, which is why he's there for the hearing today. But one of the arguments Mr. Roy had previously made to me was that he would need treatment and that's all he needed. However, he didn't check in with probation and parole when he was released from jail, and to my understanding, did not do anything to seek any kind of treatment when he was out, as he wasn't supposed to be. So I just have concerns going forward that I'm going to see any change in behavior from him, and I feel allowing him to continue on supervision would only put the public at risk for further injury or harm.
Thank you very much for your attendance today, as well as your testimony. I'm going to ask at this time if Ms. Stapleton has any questions.
Yes, well, I really don't have a question. I've got a statement, and I agree with the officer, the agent that was just on here, that the first thing you do when you do get out is you have a BAC level of 0.203. And right there it says, I will refrain from illegal use of drugs or alcohol. So you were involved in illegal activity like that, and you are a public safety risk because you certainly don't have it under control. You're drinking while driving. So I have the same concerns that she does.
Mr. Prater, do you have any questions?
No, ma'am.
And I don't have any questions either. I think that that's one of the biggest safety risks we have in public. We're prepared to vote, Ms. Stapleton.
I vote to revoke based upon your illegal activity with drinking, DWI, number 4, the hit and run, and your arrears of $141. So number 4, number 10.
Mr. Prater.
Yes, vote to revoke because of violation of Rule 4. It's criminal behavior, DWIs, and drinking, hit and run.
And my vote is also to revoke based on your pleading guilty to criminal behavior. Again, I want to reiterate, Ms. Williams, we appreciate your attendance today. That concludes our business. It's 10:09, and we're going to conclude. Thank you very much.
Thank you.
Hello. When you come on, you can't do. Somebody else you gotta try. How long has been with you?
Oh, no.
Okay.
I thought I see the time he came on.
Scream my name if you have another time, okay?
All right.
All right. I ain't gonna move. I'll be right here.
What he's doing right there? Yeah. Misty? Hold on. Misty? 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 Yeah.
Okay, good morning. The Louisiana Committee on Parole is impaneled in Baton Rouge headquarters. On my left is Ms. Stapleton and Ms. Ledoux. virtually, we have Mr. Prater. The time is 10:17, and we're handling business at Tangipahoa Parish Jail. Would the offender please state your name and your DOC number?
Willie Brumfield, 763434.
Mr. Brumfield, before we start, I want to know, do you have a piece of paper in your possession that shows your signature?
Oh, ma'am.
Okay, now do you see it on screen?
Yes, ma'am.
Okay, so the answers to that questionnaire indicate that you are not eligible for appointed counsel. Did you pay an attorney?
Oh, no, ma'am.
I'm going to read some charges of violation, and I need you to enter a plea of guilty, not guilty, or guilty with a statement. I have that you have violated condition number 4, in that the Kentwood Police Department responded to a call on 4/20/2024 for an altercation with you and Ms. Venable, and then they responded to another disturbance May 10th of the same year. An arrest was made on May 11th, and you were charged with domestic abuse battery. It is noted that on 12/2, the charges were dismissed due to lack of victim cooperation. How do you plead about that?
Not guilty.
Right. And violation of condition number 10, and your arrears of $1,136 on your supervision fees and $65 in processing fees.
I have made payments. I don't know why it don't shows that, but I knew I was kind of behind, but I have made payments, ma'am.
Okay, so guilty with the statement. Okay, Mr. Brumfield, Ms. Stapleton is going to ask you some questions, and if you'll go ahead and answer her questions.
Okay, Mr. Brumfield, I'm aware that the victim, Ms. Venable, did recant and everything, but this is officer testimony on 4/20/24 that he was dispatched for the domestic violence call and was advised by the family that there was a family get together and that everybody was drinking and that Brumfield was intoxicated. So you're not supposed to be doing that right there. That's a number 4. She further advised that her and Brumfield had words and that you became irate and hit her. The officer, Robinson, testified that Venable had marks on the face conducive to battery having occurred. Venable did advise Robinson that she had started to defend herself, but Brumfield grabbed her by the hair and dragged her down 5 or 6 steps. Robertson, the officer, advised that he observed abrasions on the victim's back and bruises on the victim's right side and bruises on both arms. You had left the scene when he got there. That's why they had to put out a warrant for your arrest. Venable advised Robertson, the officer, that she wanted to press charges on Brumfield and that she was scared for her life. So that's what was said to the officer, and that's what brings us to number 4. And that's my main concern.
Oh, well, ma'am, that's not true. The Venable, I mean, when we had the revocation here, Miss Venable came here and told officers that none of that happened. Then none of that happened. Me and Miss Venable have 4 babies together. A newborn that I missed my baby being birthed. That's not true. I never put my hands on her. I was protecting her she was hitting me. I was getting loose. She was the aggressor. I never put my hands on her.
Were you intoxicated, or were you at a party where everybody was intoxicated and you were intoxicated also?
I wasn't intoxicated, ma'am.
Well, the officer testimony of what the officer saw says differently. So I'm ready to pass it over to someone else.
Mr. Prater?
Were there 2 incidents?
Yeah, them 2 different times.
Okay, I don't have any questions.
Mr. Brumfield, you understand that, when we have evidence by the, police report of what happened, then regardless of, someone recanting, there was something that happened.
Yeah, I mean, I'm not saying that we didn't get into it, but it wasn't the whole police report thing was like totally made up. It wasn't that serious. It didn't escalate like that. I didn't put my hands on her like that. I didn't.
You were drinking?
I wasn't drinking, man. I wasn't there 5 minutes.
Well, I believe the panel is prepared to vote. Ms. Stapleton?
I vote today to revoke number 4, based on number 4, that you were charged with domestic abuse battery, and there was another disturbance later, and the intoxication that was all witnessed, the statement of the victim to the officer.
Mr. Prater?
So I vote to revoke violation of 4 and 10.
Okay, Mr. Brumfield, bad choices. My vote is also to revoke. Your parole has been revoked, and the time is now 10:24, and that concludes our business there at Tangipahoa. Thank you. Good morning. The Louisiana Committee on Parole is impaneled at headquarters in Baton Rouge. Today, serving on the panel to my left is Ms. Stapleton. Virtually is Mr. Prater, and I'm Ms. Ledoux. Would you please state your name and your DSC number for the record, sir? I'm sorry, you're on mute.
So you can hear me now?
Yes, I can.
Okay. Brian Anthony Woods Jr., DOC number 630-155.
Mr. Woods, you're before this panel today because of violations against your parole. Sir, I'm going to be reading some information about those violations and ask you to enter a plea. Before we do that, I'd like to make sure that you have a piece of paper in front of you that you recognize your signature. That's a parole revocation questionnaire. Okay, we'll put it on the screen. Okay. Do you see your name at the bottom of that?
Yes, ma'am.
Okay. The answers to the questionnaire indicate that you're not eligible for appointed counsel. However, I do see that you have retained counsel today, Mr. Marcus Myers. Has he joined us yet? Do you see him? Okay. Okay. He has not joined our call yet. So we'll go ahead and proceed. You also have several other members that would like to speak. But right now I'm going to ask you to enter a plea. Usually we have.
I'm sorry. I'd like my attorney to be here. Because he said he had spoken with y'all and he said he would be in at 11. He thought it would be at 11.
No, you can never really, we're contacting him. We'll just put you on hold for a moment.
You coming to speak? Which one y'all want to do? It's your pick. You want to do?
Mr. Woods,
Yes, ma'am.
we are making contact with your attorney. We're going to just put you to the side for a little bit until he
Yes, ma'am.
joins. So you'll hang tight and we'll come back to you at that time.
Yes, ma'am. Thank you.
So the probation officer, if you'll also make sure that you are staying connected so that we can come back to you.
Yes, ma'am.
All right, good morning. The Louisiana Committee on Parole is in panel headquarters in Baton Rouge. We're hearing an offender at Riverbend. Would the officer introduce yourself, please, sir?
My name is Lieutenant Jonathan.
And Mr. Johnson, thank you very much. Today on panel to my left is Ms. Stapleton. Virtually is Mr. Prater. I'm Ms. Ledoux. Would the offender please state your name and your DOC number?
Montreal Gang 771520.
Okay. Mr. Gaines, do you have a piece of paper in front of you that is a parole revocation questionnaire?
Yes, ma'am.
Do you recognize your signature on that?
Yes, ma'am.
Okay, the answers to that questionnaire indicate that you are not eligible for appointed counsel and you do not have a retained attorney today. Is that correct?
Yes, ma'am.
Okay, I am going to be reading the charges against you. Could you sit up so I can see you better? Half of your face is... Okay, just sit back. Thank you. We can still hear. You have been charged with violating your conditions of parole, and I'm going to read the allegations, and if you will, would you please enter a plea of guilty, not guilty, or guilty with a statement?
Yes, ma'am.
Number 4, you failed to refrain from illegal use of drugs as evidenced by your testing positive on 10/17/2024 for fentanyl and cocaine, and you were referred to our in-house substance abuse counselor, Sarah Cobb. It was determined that you needed to complete detox and inpatient treatment, and you were transported to the Grove for services. On 10/21, you were discharged from the Grove due to non-compliance. After being discharged, a parole warrant was requested and issued. How do you plead?
Guilty with a statement, if you don't mind.
I'll give you a chance to give that statement when Mr. Prater is talking with you.
Yes, ma'am.
Okay, number 7, on 11/15/2024, the PMP agents executed a warrant, and for over an hour, you refused to comply to verbal commands to exit the home, and it took at least an hour for you to comply before being taken into custody. How do you plead?
Not guilty.
And number 10, you failed to make payments toward your supervision fees and are currently $252 in arrears.
Guilty.
Okay. So let's see, you were paroled May 21st, 2024, and you were detained 11/15/2024, correct?
Yes, ma'am.
All right. At this time, I'm going to ask you to answer questions by Mr. Prater.
Yes, ma'am.
So, Mr. Gaines, your drug screen came back, but you denied using illegal drugs while you were on parole, but your drug screen came back hot.
Yes, sir.
But then you did admit to using cough syrup and Mojo. Is that correct?
No, sir. When I was my parole officer asked me what drug did I ever use, I told her when I was in jail I was smoking Mojo. When I was at home, I got shot 7 times. So I asked my grandma and my aunt for some pain medicine. The pain medicine they gave me, they got it off the streets, which was laced with fentanyl and cocaine. I didn't when I talked to my parole officer, I was scared to tell her because I thought I'll go to jail. But when I went to rehab, they tried to get me to take Suboxone pills, and I asked my family what was Suboxone pill, and my family told me that Suboxone pill is like a drug the same as fentanyl. So that's why I didn't do it, and they hold that over my head that I didn't take the Suboxone pill, and like they hold it over my head for days, and then they finally just woke me up and said they releasing me from the program.
You went to drug rehab and then they kicked you out of drug rehab.
Yes, sir, because I didn't take Suboxone pill, that drug, because my like when I took the pill that I got from my aunt,
The pill was laced with fentanyl and cocaine. It sent me unconscious. I already don't do no drugs. I don't do no pills, no none of that. And so that already had scared me in my mind to not take any pills. When I took the pill from her, it sent me unconscious. Then like 2 days later, I went to see my parole officer. That's how I had fentanyl and cocaine in my system from the fake press pill.
So you're telling them you're just a drug dealer. You're not a drug user.
No, I'm not a drug. I got a fake pill. I don't sell no drugs. I bought a fake pill. Like my aunt gave me a fake pill that she got from somebody off the street. I don't sell no drugs. I don't do drugs.
Well, I thought it said in the report somewhere that you said you just sold drugs. Did you used to sell drugs?
Oh, sir, I never sold drugs. I never had a drug problem on probation. I never went to jail for drugs. I never failed the drug test since I've been on parole. I got 5 months left on parole. I never been on no drugs. I never failed the drug test. I never did none of that. Like since I've been on parole, this is the first time I ever got in trouble on parole. This is the first time I don't even know why I'm in like so much of a trouble. And I came back to jail. I've been in jail for 2 months behind like, me taking a fake pill. I got shot 7 times. That's the only reason I even took the pill. I don't take no medication. I'm not prescribed medication. I don't do no drugs.
Okay, you got shot 7 times?
Yes, sir.
I don't really want to go into that, but that's unusual. So you got you got ordered to drug rehab because of this pill you took because you got shot 7 times.
Yes, sir. That's the only reason I even went there. And the pill that I got, it was a fake pill that was my aunt that I thought I could trust. Like my aunt didn't think somebody gonna give her a fake pill. She was just trying to help me because I got shot 7 times and my pain level was high. She didn't have intentions on giving me a fake pill that had fentanyl and cocaine in it. That was not her intention.
Okay. Did you go to the doctor when you were shot? Am I hearing that right? 7 times you were shot.
Yeah, I was shot 7 times, but that's before I went to jail. Like when it get cold outside, the pain.
Oh, okay. That was a long time back.
Yeah, that was like 2 years ago. But when it get cold outside, the aching tends to come back, and it just a real hurt.
Okay, tell me about this deal where they waited for an hour outside for you to come out, or you wouldn't come out of the house. What happened then?
They said it took me an hour to come outside. When I woke up, it took me 5 minutes to go outside. I'm telling my parole officer, because that's why she said she gonna send me in front of the board. If I knew the probation officer was outside my house, I would have got up. The only reason I didn't even hit him is I had a fan on and my TV on. My baby wasn't even crying, and my baby's only 9 months old. So that's why I'm like, they telling me they've been there for an hour. My baby would have been started crying. I would have been knew y'all was outside.
You think they just making that up?
No, I'm not saying they making it up, sir, but I'm just saying, Mr. Prater, I'm just saying, like, they probably was, but I didn't hear them to say, I'm just not opening the door for y'all. Like, that's my whole point.
Okay. I just you shouldn't have been taking that pill. I don't have any more questions.
Ms. Stapleton.
I don't have any questions.
Mr. Gaines, I distinctly heard you say you only smoked Mojo in prison.
Yes, ma'am.
Okay. Is it permissible? Is it okay to smoke Mojo in prison?
No, ma'am. I said, no, ma'am. That was,
So you didn't follow the rules while you were in prison, is what you're saying?
No, I'm saying like that's what when my parole, I was asking me what drugs I ever did. I said when I was in jail, I smoked Mojo one time. That's what I told her. I said I didn't. I don't. That's what I was saying. Like that's the only drugs I ever did. When she asked me what drugs have I ever did in my life, that's what I told her.
Okay. The statements we have received from the treatment facility are very disturbing about what you said. And you are on parole for crimes of violence, right? A crime of violence. So and that concerned me. So, Mr. Gaines, I think the panel is prepared to vote. Mr. Prater, are you prepared?
Ma'am, yes, ma'am. I vote to revoke because of the violation of rule number 4, rule number 7, and rule number 10.
Ms. Stapleton.
I concur.
Mr. Gaines, by the preponderance of evidence, the report that we have received being dismissed from treatment, my vote is to revoke your parole. So at this time, you've been revoked, and we're going to close off there at Riverside, River Bend. It's now 10:50. Thank you.
We got to vote. Scott, you got to vote. I don't know. So it looks like yes. No, they didn't go yet. Thanks. Oh. See that other dude, the Mike Games? That's one that's he's in our custody, but he's at River Bend. Will Brunfield.
So they want this person now. They say they want a picture, his information, and that, or whatever.
Oh, just send them this. Just send them the picture.
Right, good morning. This is the Committee on Parole. We're impaneled in headquarters in Baton Rouge. Serving today on my left is Ms. Stapleton. Virtually is Mr. Prater. I'm Ms. Ledoux. I noticed there's someone there at the East Baton Rouge Parish Prison. Sir, would you please introduce yourself, the officer?
Yes, ma'am. Lieutenant Murphy.
Hey, Lieutenant Murphy, thank you for joining us. This time, would the offender please state your name and your DSC number?
My name is Marcus Allen. My DOC number is 442734.
Mr. Allen, you're before this panel due to allegations of violation of your conditions of parole. Before we get started, do you have a piece of paper in front of you that has your signature? That
Yes,
indicates, okay, and it recognizes your signature.
Yes, ma'am.
Okay, that indicates that you are not eligible for appointed counsel, and I don't see any retained counsel. I'm going to read the allegations against you, at which time I would like for you to enter a plea of guilty, not guilty, or guilty with a statement. Rule violation number 4, you were involved in criminal activity in the commission of the offense of simple assault, other force in West Baton Rouge Parish under incident report 2463 by the Port Allen Department on 10/27/2024. How do you plead?
Guilty with a statement, ma'am.
Okay, we'll get to that statement. Mr. Prater can ask you about that. Also, you failed to make monthly supervision fees, and no payment has been made since June of 24. You're in arrears $252. How do you plead?
Guilty with a statement, ma'am.
Okay. Okay, if you will, answer questions by Mr. Prater.
Okay.
Okay, Mr. Allen, I'm trying to figure out here, tell me about the stalking and threatening a victim. You showed up, you made some cell phone threats to this lady. Is that true?
Yes, sir, I did.
Okay. What did you threaten to do to her?
Well, sir, I told her that I was going to slap her and that I was going to mess up her restaurant.
Okay. And did you show up at the restaurant?
I did, sir. I showed up at the restaurant afterwards, like 20 minutes after I had made those threats. I had thought about it. And this is a lady that I'm in a relationship with. And I had thought about it, Mr. Prater, and I was like, I need to make this right. And I know that I went about that the wrong way.
Okay. And so then you she left the restaurant and you followed her. Is that correct?
Yes, sir. When I seen her and she got into her vehicle and she was motioning with her hands and I didn't know what she was saying. So I called her and she had done left already and had told me that she was going to the police station and she said that she thinks I need to go there and sit down and talk with them. And I put Port Allen PD in my GPS and I went there. I thought she was pulling my leg at first, but when I went over there, I seen her vehicle was over there and I went over there. I know I'm on parole and I didn't want any of this to get back to my parole officer. So I did go. And I spoke with the officers and they asked me what happened and I owned up. I told them what was going on. I told them what I'd done. And, you know, all those things were said out of anger, you know.
Had you been stalking her for 2 months?
No, sir. I haven't been stalking her. That the whole thing with that was she wanted to just give the relationship a break for 2 months. And that's whenever I just went in my feelings, Mr. Prater. And, you know, I thought she was cheating on me. I didn't know what was going on. And
okay. Did the officers at Port Allen try to get you to sign a paper saying you wouldn't go back to the restaurant?
they did. She told me, the lady did, the officer did tell me that. She said, I don't have to. You know, I don't have to sign if I don't want to. But she said, look, just for right now, just don't go around the restaurant and just don't call her. You know, and this took place on October the 27th. I got emotional.
Why didn't you sign the paper?
I don't know, sir. I got emotional. I started crying and I left from out the police station. They came out, asked me if I was okay. I shook both their hands and I left. And
okay. Are you a registered sex offender?
Yes, sir, I am.
Okay. When did you start dating that lady?
Back in February.
And were y'all dating in May?
Yes, sir.
Okay. Let me just ask you this, because it's, I think, being a registered sex offender and the fact it's noted in the probation parole, and because it concerns me, is when you went to the probation parole office in May of 2024, before you went through the metal detector, you pulled out and they said you had a pocket full of condoms. Being a registered, I wouldn't normally get into private people business and all that business, but you dating somebody and so much in love with them that you'd stalk them, yet you got a pocket full of condoms. And I understand they can be for, you know, to keep from getting pregnant. I understand a lot of things, but that's kind of unusual. I know in, you know, the big joke about somebody in high school got one in their wallet or something, but a pocket full, a grown man, a grown sex offender, that don't make sense to me. What's the deal?
I just have them, sir. Every time I go to probation and parole, I mean, I was using protection, you know, and I didn't think that would be a problem.
I mean, I'm not saying it's a problem. I'm just kind of trying to get to know you a little bit.
Yes, sir.
Okay. And notice you're number 10. How much money are you owe? Don't you owe some money to probation and parole?
Yes, sir, I do.
How much?
Right now, sir, I'm at $252 in the hole.
Okay. Not a whole lot.
It's not a whole lot. That was going to get taken care of, sir. Mr. Prater, I'm not going to lie to you, sir. I have been mismanaging my money. It's nobody's fault but my fault.
Okay. And you got 15 years and 15 years, total of 30 years. If you put them together, you were paroled in January 24, and here you're already in trouble for some pretty serious charges.
Well, I don't have no charges against me, Mr. Prater, but I'm in violation, sir.
Yes, sir. Some pretty charges that you violated some rules. You're right. You're saying
Yes,
it
I mean,
right
I violated.
you're saying it right, and I'm saying it right. Okay. I don't have any more questions.
Mr. Stapleton?
Yes, I've listened to, Mr. Prater and the questions that he had for you. Very concerning for me since, you did have an aggravated sexual assault charge.
Yes,
And
ma'am.
I can understand why this lady would be, well, you gave her threats. You gave her threats, she showed up. And the stalking charge, I think, was valid. So all of that does concern me very much. So I see too that you pled guilty to these things at one hearing. So I have no questions.
Mr. Allen, if you needed to get anger management, you were at the Pearl Project. You didn't take anger management classes?
Yes, ma'am. I mean, parole project, they have been there for me. And
Did you anger management classes?
yes, ma'am. And
So non-compliant with that I mean, that didn't necessarily help you with the anger.
no, I mean, it's not that, ma'am. I messed up, Miss Ledoux, and
Okay, well, and unfortunately today you have to answer for that, okay?
well, Miss Ledoux, yes, ma'am.
I think we have enough information, Mr. Allen. Mr. Prager, if you would begin with the vote.
My vote is to revoke violations of Rule 4 and 2 and 10.
And Ms. Stapleton.
I concur.
And Mr. Allen, based on your guilty pleas, my vote is also to revoke your parole. I hope that it goes better next time. Okay?
Yes, ma'am.
Thank you. That concludes our business at 11:07 with East Baptist Parish Prison.
Good luck to you.
Hang on, give me a second.
Ready to go on the record? All right, the jurors just passed a note. I'm putting the note under seal, but it's 9 o'clock, which is when they said they'd stay till. So they still need to deliberate. Was in essence the gist of the note that I got. We'll use the word gist. So I'm going to bring them back in. I'm going to give them an instruction as to, and I'll beef up the do not talk, do not do anything on this. And then what time can I get them in here in the morning? If I'll see how they feel. I mean, obviously we're going late, so they may not want to get here at 7:45, but I'm talking with security. We can get at least the participants for this case in here a little bit earlier if we needed to. But I'll see how they feel about. Maybe forget everything I just said. All right. The second note that the jurors just passed was, does anybody want pizza? We have plenty left over. They are good characters, that's for sure. But the first note I'm putting under seal for now. But I'm just going to bring them in and instruct them and then see what time they want to get here to start first thing in the morning. All right. Everybody good with that?
Yes, and I showed the question I'm raising mine. Can you, without disclosing what's in the note, can you explain why you're placing it under seal?
No, I'm just saying I'm placing it under seal.
Okay.
All right.
Yep.
Anything? All right.
No, Your Honor.
All right.
Do you want them to bring their notes with them? So they're organized?
Yeah, they need to bring their notepads back with them and put them in their folders and leave them here tonight, and we'll collect them and give them back to them in the morning. Yeah. That one. That's I do, on behalf of myself and the parties, I do appreciate y'all being troopers today. It has been a long day, but I do appreciate it, and we really do. Based on your last note, what I was going to say is we're going to go home for the evening. I know we've been starting, getting you here at 8:15. We can get you here in the courthouse earlier before they open if y'all are willing to do that. So we can be seated, or y'all can be back there by 8 o'clock, ready to roll. I know it's late though, so I'm kind of leaving that up to you. Do you want to come at 8:15? Do you want to come at 7:45? Y'all want a sidebar with the static?
I was thinking 7:30.
Can we do 8:15, y'all? I'm not barely making it on time, and I'm gonna be honest, so.
Okay, all right, we'll just get here at 8:15, then we won't have to worry about that. Just come to the circuit reception area where you guys will be coming. We'll get the bailiff to bring you up and get you in the courtroom. Your notepads and stuff, leave them on, leave the folders here. We'll collect them, have them for you when you come back in the morning like we've been doing. And then let me just read our instruction for, I said before it was for the last time. Now at least do it one more time, but we're going to take our recess for the evening. Remember, all the rules I've given you apply even when we're outside the courtroom, such as at recess. And this is, since we've started deliberating, especially at this point in time, this is the most important. As a reminder, remember the basic rule: do not talk to anyone, including your fellow jurors, friends, family, or coworkers, about anything having to do with the trial except to speak to court staff. That means no emailing, text messaging, tweeting, blogging, or other form of communication. Do not do any research about the case or look up any information about the case. And, you know, especially the stage that we're at this point in time, I know people like to hop on Facebook or looking at whatever.
No research.
Try to avoid that in any means that you possibly can overnight. Remember to observe during our recess the other rules that I gave you. If you become aware of any violation of any of those rules at all, notify court personnel. And then when you get back here in the morning, just make sure your phone or electronic device is turned off. We'll leave them in the courtroom like you did today while you're deliberating, but we'll get you back there. But I do appreciate y'all putting in a little extra, little more than a little overtime tonight, because we, like I said, just from a scheduling standpoint, you know, we're concerned about tomorrow. But anything else from the plaintiff?
Well, are one of these nice gentlemen gonna watch us check cars?
Yeah, Bailiff's going to take you out, and if you can get, escort them out to the parking lot.
Got somebody at the front door.
You got somebody at the front door that can do it. Okay, yeah, we'll get you down there. But anything else from the plaintiff tonight?
No, Your Honor, thank you. No, Your Honor, thank you.
All right. Well, y'all get a good night's sleep because y'all definitely earned it. All right, we argued the jury instructions earlier. And we're working off the defendant's set. So I'm looking at the defendant's proposed instructions for phase 2. Number 1 was stipulated to by the parties, so that's being given. I don't know if y'all modified that to begin with, but however, the form that I got I'm giving it in that form. On jury instruction number 2, y'all had stipulated to it with the exclusion of the last sentence of you should impose punitive damages only if, et cetera. So I'm going to take off that last sentence. Otherwise, I'm giving 2 as is. On instruction number 3, that was where I had talked about moving the word only. And after going back and forth, I think as it's written, it makes sense, but I'm going to give that as written. Defendant's proposed instruction number 4, I'm not going to give that one. And then 5 and 6 were stipulated to as written, so those will be given as written. All right, so really the only modification on here is as to number 2, taking off that last sentence. 3 is given over the plaintiff's objection. 4 is not being given over the defendant's request, and everything else is, I think, stipulated to. So I'll clean it up with taking that sentence off, and I'll take off the headings, but I'll send you a set as revised tonight. And then because I'm leaving, proposed number 2 as written, I think it makes sense just having the one question verdict form that we had all talked about before. So I'm just going to have the verdict form be the one question of what's the amount. Okay. I think, which was the defense version to begin with, that y'all had agreed to. And then when I started talking about number 2, I was going back and forth as to whether we needed a second one, but I think it makes sense to just have it as one question. So that'll be the verdict form.
So does that mean, Your Honor, that I guess Roman numerals 1 and 2 are being put back into the instruction?
Yeah, I'm leaving little I-1 and little I-2.
So I guess my only question is, so if we get a verdict, how do we know which cap will apply?
Well, that was my question that I was posing, but the resolution of that is based on the definition, I think, of express malice, that if there's a finding of express malice, it's automatically finding the intent to harm. So that lifts the cap.
Okay. Thank you.
So if they find entitlement to punitives, I think that automatically lifts the cap.
Thank you.
That was my rationale of leaving 1 and 2 in there, because that's the complete instruction. And that resolves the question of not having the second question on the verdict form.
Understood.
That's my rationale. So I'm glad you asked the question. Thank you, Mr. Delich.
Yeah, thank you, Your Honor.
All right. All right. Anything else for this evening? It's way past everybody's bedtime.
Not for plaintiff.
Nothing further, Your Honor. Thank
All right. Well, I appreciate it. And yeah, I didn't say this before. I know we've had our ups and downs over the last almost 2 weeks, but you know, everybody, other than some of the comments, everything was tried very professionally. I commend the IT folks in running the projection of stuff, because I think that ran very, very smoothly with having that rolling when y'all were pulling up exhibits. So I do appreciate that.
Thank you to all the court personnel too for all their hard work.
We're just public servants.
I wasn't referring to you.
So noted. Hey, it's so stipulated. All right, now I appreciate it. Everybody get a good night's sleep, and we'll see you back here at 8:15 in the morning.